in a seismic clash that reverberated through the legal world and left Supreme Court Justice Brett Kavanaugh visibly stunned. Congresswoman Jasmine Crockett, a second-term Texas representative and former civil rights attorney, delivered a breathtaking constitutional masterclass during a House Judiciary Committee oversight hearing on September 19, 2025, transforming a routine session into a historic confrontation that exposed glaring inconsistencies in the Supreme Court's First Amendment jurisprudence and ignited a national conversation on judicial accountability. The 59-year-old Kavanaugh, a Yale-educated textualist and originalist who has anchored the court's conservative majority since his contentious 2018 confirmation, sat confidently at first, having cultivated an image of measured judicial temperament to distance himself from the raw emotions of his confirmation hearings. Known for his alignment with conservative priorities like executive power, religious liberty, and free speech, he was there to discuss the court's recent First Amendment decisions, cases on protest rights, campaign finance, and religious expression that critics argued showed ideological bias in applying constitutional principles. When Crockett, a University of Houston Law Center graduate with 15 years of litigation experience defending constitutional rights, took the microphone, Kavanaugh likely expected routine inquiries. Instead, he faced a relentless, meticulously researched critique that would reshape perceptions of both the court and congressional oversight. The stage was set when Crockett, dressed in a navy suit with a Constitution-themed lapel pin, began with the deceptively simple question about Kavanaugh's concurrence in Americans for Prosperity versus Bonta, where he emphasized that consistency in constitutional interpretation is essential to the rule of law. Nodding comfortably, Kavanaugh agreed, unaware that Crockett, armed with a binder of case excerpts and an in-depth study conducted with leading constitutional scholars, was about to dissect his jurisprudence with surgical precision. She zeroed in on contradictions. In Bonta, the court applied strict scrutiny to protect donor privacy as an associational right, yet in McKesson v. Doe, it allowed potential financial ruin for protest organizers under a lax standard, despite both cases implicating the same First Amendment freedom of association. What constitutional principle justifies this different treatment? She pressed, her tone professional but unyielding. As Kavanaugh shifted in his seat, offering that different contexts required different approaches, Crockett countered with another damning comparison. In Kennedy versus Bremerton School District, the court dismissed speculative coercion to protect a coach's public prayer, yet in City of Austin versus Reagan National Advertising, it upheld sign restrictions based on vague aesthetic concerns, applying divergent analytical frameworks to similar expressive rights. The packed hearing room grew deathly silent as Crockett's questions intensified, each one grounded in specific case law, historical references, and Kavanaugh's own writings. She cited his 2012 Harvard Law Review article, where he called viewpoint discrimination the cardinal sin of First Amendment jurisprudence, then revealed a staggering pattern. In 23 First Amendment cases since his appointment, Kavanaugh applied strict scrutiny 100% of the time to religious, corporate, or conservative speech, but only 9% of the time to protesters, labor groups, or civil rights advocates with identical claims. Displaying side-by-side opinions on a screen, she highlighted how two Kavanaugh-authored rulings, just 4 months apart, used conflicting scrutiny levels for nearly identical government restrictions, differing only in the speaker's identities, religious versus secular, conservative versus progressive. The First Amendment offers no hierarchy of protected speech, she declared, quoting Madison's writings and early court precedent to underscore that the original public meaning demanded equal protection for all expression, a principle Kavanaugh's voting record seemed to defy. Kavanaugh's attempt to dismiss her as lacking significant legal expertise backfired spectacularly. Without raising her voice, Crockett retorted, "Justice Kavanaugh, I litigated constitutional cases for 15 years, including First Amendment claims that reached the Fifth Circuit. I'm quite familiar with how these principles work in practice." She then unveiled a chart mapping 7 major First Amendment cases from the past 3 terms, showing strict scrutiny consistently favored conservative or religious speech, while rational basis or intermediate scrutiny was applied to progressive or labor-related expression. This is not consistent constitutionalism, she charged. It's outcome-driven jurisprudence. Even Republican committee members, including a former D.C. Circuit clerk, nodded in respect, one whispering, "That was a masterclass in constitutional analysis." As Crockett concluded, warning that inconsistent scrutiny undermines the First Amendment's core purpose, protecting all expression, not just the popular or powerful. The room erupted in murmurs, and journalists scrambled to capture the historic moment. Kavanaugh, visibly flustered and adjusting his tie, could only muster a vague defense about the complex interplay of precedent, failing to address Crockett's specific critiques. Chairman Jim Jordan, sensing the moment's weight, allowed a response, but Kavanaugh's words lacked substance, leaving the impression that a Supreme Court justice had been outmaneuvered by a congresswoman he underestimated. The fallout was immediate. Within hours, clips of the exchange went viral, amassing 30 million views and sparking trending hashtags like #CrockettSchoolsKavanaugh. Legal giants like Harvard's Lawrence Tribe praised her precise and substantive challenge, while conservative jurist J. Michael Luttig called her concerns legitimate and worthy of serious consideration. Major outlets like the New York Times and CNN dissected her arguments, with scholars confirming the scrutiny disparities she exposed. Law schools from Georgetown to Yale incorporated the exchange into curricula, commissioning symposia and journal issues on the Crockett test, whether justices apply consistent scrutiny regardless of speaker identity or ideological slant. Inside the Supreme Court, anonymous sources told The New Yorker that Crockett's critique prompted rare internal discussions, with even conservative justices acknowledging tensions in their First Amendment doctrine. Kavanaugh's subsequent opinions showed a subtle but noticeable shift, emphasizing viewpoint neutrality and consistent scrutiny in ways that echoed her arguments, though he never cited her directly. For Crockett, the hearing catapulted her into a national spotlight. Law schools invited her to lecture, the American Constitution Society tapped her for a keynote, and the National Bar Association created a Jasmine Crockett Prize for constitutional analysis. Her performance, rooted in her experience as a civil rights attorney, became a beacon for underrepresented voices, with young women of color flooding social media with stories of inspiration, one TikTok declaring, "She didn't shout or get emotional. She just dismantled his reasoning with his own principles." The exchange reshaped congressional oversight, inspiring the Crockett model of substantive, evidence-based questioning over political posturing. Her proposed Judicial Transparency and Consistency Act, requiring the court to justify scrutiny levels in constitutional cases, gained bipartisan traction, endorsed by conservative groups for promoting principled judicial restraint. A Pew Research poll showed 71% of Americans, across party lines, now favored greater judicial accountability. Months later, during a major First Amendment case on protest rights, Kavanaugh's questions and concurrence reflected Crockett's critique, emphasizing consistent scrutiny, a shift scholars called remarkable. A year on, the Georgetown Law Journal study on scrutiny standards, inspired by Crockett, became required reading, while law books now feature the exchange as a case study in constitutional dialogue and accountability. This electrifying moment, where expertise, preparation, and fearless principle held power to account, proved that rigorous scrutiny from co-equal branches strengthens our republic. If it inspires you, hit like, subscribe for more unfiltered breakdowns of governance's defining moments, and share your thoughts on when knowledge has triumphed over assumption in the comments below.